Hi, I'm Jonathan Meyers. I'm a New Jersey and New York employment attorney, and I'm here to talk to you today about whether professionals can claim age discrimination without harming their reputation. Okay, so this is part one of a two-part series, so if you want to come back and see part two, please do. But first, a brief disclaimer. In this video, I'm not providing you with legal advice. I'm not your attorney. If you want me to be your attorney, give you legal advice, represent you, then contact me and we would need to enter into a written retainer agreement. Okay, so let's get to it. When people are fired for unlawful reasons, like age discrimination, perhaps you've been let go as by a younger boss and you're replaced by someone younger, maybe there were some age-related comments. When that happens, people in that situation naturally want to know what their legal rights are. Can they sue their employer? Will they have a good case? How much will they get? Those are good questions, but smart, well-educated people probably are also going to give some pause to think, well, what if other people, what if other employers find out that I claimed age discrimination? Will that tarnish my reputation? Will new employers think less of me? Will that prevent me from ever getting a job again? So here I'm going to briefly explain to you what to expect when you retain an employment attorney to take action with some of these reputational considerations in mind. So the first important point is don't make decisions in the heat of the moment. You really need to think ahead, okay? It's important to take a step back, think about your situation with some long-term perspective. Now, it's natural for you to be upset and angry if you've just been fired, or if you've been given the signal that you're about to be by being placed on a performance improvement plan, or being frozen out of meaningful work, or just something else that shows you that the writing is on the wall. Right? It's normal to want to reach out for the most immediate and extreme measures of pushing back at your employer, and that usually entails filing a lawsuit. But please consider that these feelings will ultimately pass. You will move on, and whether that's to a new job of your liking or to a lesser job or something else, you really will move on someday, and this will be behind you and you'll have some peace. Decisions about whether to sue or to take advantage of some of the other options at your disposal, which we'll talk about, these should only be made when you are sober-minded, when you're thinking not just about the wrong that you've suffered, but also about your future and career prospects and financial status next month, 5 years from now, 10 years from now, etc., out in the future. Snap decisions made in the heat of the moment can cause you to say things that you may regret forever, or put you down a path that isn't really right for you and you wish you hadn't gone down in retrospect. So we have to slow down a little bit when we're thinking about these issues and making decisions. So second point, talking about we making decisions, right? The second thing is you do need to retain legal counsel to explore your options. That's very important. While filing a lawsuit may be an option, it's not the only option, nor is it necessarily the best option. You really do need to make a reasoned judgment about how to proceed after considering all the options. And that's why you should see an employment attorney. I recommend that any professional who values their career, their reputation, their financial status, do retain an employment attorney to help them explore their options and take the actions that are necessary and appropriate for their situation. We employment attorneys have experience and knowledge to help you with this. We've been through the situation for clients again and again and again. We've been down this road. We know where it goes. It is worth your time and effort and resources. So what are your options? What are some potential options for you? Well, for the most part, they consist of 5 things. One, getting behind the scenes advice from an attorney. 2, having an employment attorney write a demand letter for you and negotiate on your behalf. Number 3, file an administrative charge. Number 4, file a lawsuit. That's the big one. Or alternatively, file arbitration. We'll talk about each one of these options, and we're going to start with the first 2, and then in part 2 of the video series we'll go into the other ones. So each of these methods has pros and cons associated with them, both in terms of results, and that's the compensation you might receive, and also reputational impact, and that can vary with each of these. So I'm going to give you a preview right now. There is usually no easy way to choose one of these options. Sometimes there is, but usually it requires some real thought and usually ultimately making a judgment call. That said, you want that judgment call to be as well informed and calculated to benefit you the most as possible. So we're going to talk about these first two options today in part one of this video. Option number one, this is what I call getting behind the scenes advice from an employment attorney. This is usually the best option when an individual has been let go and offered a fairly generous severance. Often when an employer ends someone's employment involuntarily, the employer will offer a severance payment. Employers don't just do that out of the kindness of their hearts. They are paying you the severance to purchase something from you. They're buying a release from you, and that is a promise that you will never sue them. If the severance money that's being offered to you is pretty good, then it might not be worthwhile to file a lawsuit or an administrative charge. And that's particularly so if you don't have a very strong claim. The advantage of entering into a severance agreement is that it helps you avoid a legal fight with the employer. You don't have to spend the time, effort, money, resources associated with litigation to get a result. And you also get certainty. You know what you're getting. What the severance agreement says you get is what you get. And it's also pretty quick. Litigation and some of the other things we'll talk about can take months, years, a long time. A severance agreement usually is weeks, very quick. This option can help you avoid having your legal dispute with your employer aired publicly. It's very private. And typically, with the attorney acting behind the scenes for you, the employer doesn't even know that you've retained counsel. And of course, this is one of the least time-consuming and expensive things a lawyer can do for you. So it's probably going to be the cheapest option. Now, even if you're offered a severance and you think it's financially pretty good, it's still worthwhile to get legal advice. And why is that? Because the attorney can advise you about the likely impact of the severance terms on you. Sometimes these severance agreements have things like non-disparagement clauses, which may not be mutual. They could have restrictive covenants, that is non-compete, non-solicitation terms, non-disclosure terms, no rehire clauses, and these things can have a lasting impact on you. So it's important to consider and know what they mean. Maybe you can negotiate them, and even if you can't negotiate them, it's important to know what limits that puts on you in your future career search. And sometimes also, an attorney can think of issues that you haven't thought about, such as, what's the employer going to tell reference checkers in the future? Will the employer oppose an application you make for unemployment? So could be some real value to you having your agreement reviewed by an attorney. Of course, if you have the makings of a good age discrimination claim and the severance being offered to you isn't that great, then it may make more sense to press forward with a claim or a lawsuit. So again, getting advice on this is one of the least expensive kinds of work that an attorney can provide. And think about it. If you're willing to pay a plumber to fix a leak, why wouldn't you pay an attorney to help you with what could be a monumental pivot in your career, right? All right, let's talk about option number two now. And this is where the attorney sort of does something more substantive for you. They write a demand letter and negotiate on your behalf. And here the attorney is making an appearance for you by writing a letter to the employer, so the employer knows you have an attorney and that you're represented. And usually this letter, what we call a demand letter, will explain that you'll be represented. You plan to bring a legal action unless the employer agrees to an amicable settlement before the suit is filed. Now, usually this kind of letter will set forth a lot of facts and the applicable law, and it tries to make it look like you're very serious. It tries to grab the employer's attention, right? It tries to motivate them, get you some leverage to negotiate a severance. Now, this option can turn up the heat a little bit, and that's because the employer knows that you're represented by counsel, but the letter also will accuse the company of age discrimination and maybe some other bad things too. So what kind of reaction are these letters get? Most sophisticated employers that have in-house HR and legal staff, they get these letters all the time. It's routine. They're not shocked by them. However, just keep in mind that the letter could get back to your old boss and they might take it personally. These demand letters often do lead to settlements. If the employer takes the demand letter's threat of litigation seriously and offers you something that you find acceptable, then that's great. You're done, and you didn't have to work too hard for it or ruffle too many feathers to get it. So that's a good way to get a resolution. Now, of course, one of the pros of this methodology is that it is private. It's very unlikely that the outside world will know that you threatened litigation. Even if your old boss gets the letter and they're angry about it, he or she probably wants to keep that under wraps even more than you do. The downside with demand letters is that some employers don't always take them seriously. Some employers just won't make offers in response to demand letters because they think that the employee just won't follow through with the lawsuit. And some employers just don't recognize the seriousness of legal action. Many small companies, even those handling millions of dollars of business each year, may not be used to employment law issues and don't know how to respond rationally and don't know the risks associated with litigation. Something else to think about is you may want to move fast, and I often get that impulse from clients, but your attorney may want to proceed at a measured pace, and they're probably doing that for practical reasons. It's not just because the attorney is slow or lazy or forgot about you. There's usually reasons for it. For example, in my practice, I typically don't send out a demand letter until after my client files for unemployment and that agency makes a determination about whether to pay benefits and an appeal period has passed. And why is that? And that's because I want to avoid the risk of being hasty and sending out a demand letter too quickly, and then the employer gets it, and then it prompts the employer to retaliate by opposing unemployment. Hey, I got your demand letter. I was going to let you have your unemployment, but now you made me so angry, I'm going to oppose your unemployment. You wait until the agency makes its decision. We can avoid that whole scenario. What if the demand letter doesn't work? What if the company just refuses to offer you anything, or it only offers you a pittance? Here's a bag of donuts, and that's our best offer. You should be real grateful for it. Then we have to press forward, and we'll talk about that in part 2 of the series. We'll talk about some options that may pack some more punch, but they're also less likely to be private. They're probably more likely to be public. So come back here for it, and I look forward to seeing you again.